Sure, I'm Steve Shapiro. I'm the National Legal Director of the ACLU. I was been very lucky in my career. I went to law school thinking that I might at some point, if the stars aligned, wind up doing constitutional litigation at the ACLU. And it turned out to be the first job I had following a clerkship, and I've stayed here ever since. No, I very much grew up in the 60s and lived through that rights revolution at a moment in time, maybe an historical anomaly as it turns out, but a moment in time when the courts really were agents for progressive social change and for protecting and promoting more rights for more people. And so I went to law school thinking that that was the kind of work that I wanted to do. My father was a New York City civil servant, but a frustrated lawyer, I always thought. My sister went to law school before me, and so I followed in the career path, and I took a lot of constitutional litigation, constitutional law. From some very good teachers when I was at Harvard, came out, got a clerkship, and then really, as I said, in many ways lucked into a position at the ACLU. I clerked for a judge on the Second Circuit whose name was J. Edward Lumbard. He had been Chief Judge of the Second Circuit for many years. He was a close friend of Justice Harlan. And by the time I went to clerk for him, he had recently gone senior. He was probably in his early 70s. He had a very different set of politics than I did. He was I would say, a Dewey Republican, an Edwardian gentleman. He had been the U.S. Attorney in the Southern District of New York, and is given credit, and I think properly given credit, for really creating the office that we now know as the Southern District of U.S. Attorney's Office. He brought in the best and the brightest, and a tremendous number of alumni from that office, then went on to serve on the federal bench. And it was, I think, even though he was only U.S. Attorney for a couple of years, the formative experience in his life. He was very much thought like a prosecutor, but had tremendous faith in the system, and therefore a tremendous commitment to seeing that the system operated fairly, and was more upset because his expectations were higher than others might be when he thought the system failed, either the public or the defendants. He didn't delve deeply into doctrine. He was a pragmatist, but he taught me a lot about how the judicial process works. He taught me a lot about writing, and the last thing he said to me when I went to say goodbye at the end of my clerkship year was, he said, "Steve, if you've learned nothing else from me, I hope you've learned the value of an afternoon nap." So I've taken that lesson with me also for life. That's fair to say. In most cases, even in a court like the Second Circuit, of course, do not go to the United States Supreme Court. It just like the vast majority of cases that the ACLU handles don't go to the Supreme Court, even though we have a fair number that do. And what I thought was very good about Judge Lumbard is he obviously tried to follow the law. He understood he was bound by what the Supreme Court said, but he pretty much did what he thought was right. And I remember saying to him one day, how do you feel when a decision of yours is reversed by the United States Supreme Court? And he looked at me and said, "I think they're wrong." Well, I was doing what all federal appellate clerks do, but this was back in 1975 and 1976. It was a quieter time. Circuit judges had only 2 clerks then. They didn't have 4. And we read briefs, we prepared bench memos, and we drafted opinions for him. I did, although this is a story that I love to tell to aspiring law students. I was sitting in chambers sometime in the spring of 1976 trying to figure out what I wanted to do with my life, or I knew what I wanted to do with my life, just trying to figure out how I would get there. And I saw an announcement for what at the time was a relatively new fellowship at the ACLU called the Karpatkin Fellowship. It was the second year of the Karpatkin Fellowship. And it was to come work at the ACLU national office for 1 year, and I applied for it and never heard anything. I certainly didn't get the job, but as I recall it, I never received a rejection letter either. It just, my application was met by stunned silence. And then about a month later, I got a call from a woman named Marcia Lowery, who worked at the New York affiliate of the ACLU, the New York Civil Liberties Union. And she called me to say that she was looking to hire a young lawyer to work on what was then called the Children's Rights Project, which really did institutional reform litigation involving the New York City foster care system. And she said, I got a list of candidates who had been finalists for the Karpatkin Fellowship, and your name was on the list. Would you like to come in and interview for this job? And my first reaction was, I was a finalist. Nobody ever told me. But I did go in and interview for the job, and I wound up getting that job. And it was fortunate in many ways because the ACLU was much smaller in those days. And had I actually received the fellowship, I almost certainly would have left after 1 year. There wouldn't have been any other opportunities, and my career would have gone off in some other path. Because I didn't get the 1 year fellowship, I wound up getting a full-time job. And I came and did that job with Marcia for, I don't know, a year and a half or 2 years, got a lot of very helpful and useful litigation experience. But then there were a variety of people at the New York office of the ACLU who were moving on for one reason or another. And so there were some openings to do what we think of as general civil liberties work instead of specializing in one particular area. And I was always interested and have remained interested throughout my ACLU career in the opportunity to work on the range of issues that the ACLU works on. So I moved over from being a specialized lawyer working on these institutional foster care cases to an ACLU generalist. So I did a lot of First Amendment work. I did some Fourth Amendment work. I did some equal protection work. I did what ACLU lawyers and ACLU offices do, and I stayed there for almost 8 or 9 years. And then there was an opportunity to move to the national office of the ACLU, first as deputy legal director in 1987, and then as the legal director in 1993. So I have been the ACLU's national legal director since 1993, and part of what I have done at the ACLU since really I came to the national office in 1987 was to supervise all of the ACLU's work in the United States Supreme Court. So for the past 25 years, I have been intimately involved in every case that the ACLU and every brief that the ACLU has filed in the United States Supreme Court, and that's a lot because we're a pretty frequent participant. Well, the way the ACLU is organized, and part of the strength of the ACLU as an institution, is we have a national headquarters, primarily located in New York, but with a lobbying office in Washington. And then we have state offices in every state of the country. I directly supervise the legal work of the national office. I do not, on a day-to-day basis, directly supervise the work of the state affiliates. So their decisions about whether to take cases or not are made at the state affiliate level, and not only I usually do not have any input into that decision. I often don't know about it because it's a big organization and there are a lot of litigations going on at any given time. But the place that the litigation program gets centralized is when a case is heading to the United States Supreme Court. So whether it started in the national office of the ACLU or started in a state affiliate of the ACLU, if an ACLU lawyer thinks a case is a candidate for us to seek Supreme Court review, or if an ACLU lawyer receives a petition for certiorari from the other side because we have one below, the case at that point comes to me. And I will make the final decision about whether we are going to petition, and if the petition has been filed against us, then I will work with the lawyers to shape the op cert that we are going to file, and if a case reaches the merit stage, then I will work and have final edit on any brief that is submitted to the Supreme Court, and will work to ensure that the lawyer who is going to be arguing the case is properly prepared to argue the case. That's true for the direct cases we bring to the Supreme Court. We also have a pretty active amicus practice to the Supreme Court, and the amicus practice much more tends to, not exclusively, but much more tends to start with me. I follow the Supreme Court docket, identify the cases where we have an interest and I think we might have something to say. I then try to map out what it is we're going to say and figure out who then is going to draft the amicus brief. Well, the ACLU was founded in 1920 in the aftermath of World War I, and it was really founded in response to two principal events. One was a series of prosecutions under the Espionage Act for people who protested American involvement in World War I and were sent to jail on the theory that their anti-war speech discouraged people from enlisting in the army and therefore interfered with the war effort and was therefore a crime under the Espionage Act. And those cases led to the very first decisions by the United States Supreme Court really interpreting the meaning of the First Amendment in 1919. Simultaneously with that, there was a period, a moment in time when the Attorney General of the United States, whose name was Mitchell Palmer, in response to a series of bombings, really, including a bombing at his home in which he was not injured, launched what became known as the Palmer Raids and rounded up literally thousands of immigrants from the United States and deported them without any due process, simply put them on ships and sent them back primarily to Eastern Europe. And so in response to those mass deportations without due process and the prosecutions and conviction of war protesters under the Espionage Act, a group of people got together and said there should be an organization whose mission is to defend the Bill of Rights. And they created the ACLU, and part of what is interesting is the Constitution at that time was largely an aspirational document. It set out a series of values in the Bill of Rights, but there was very, very little law that suggested that those rights were enforceable in U.S. courts. And so the Constitution, as we now have come to understand it, not as a series of simply ideals, but as a series of enforceable rights, is very much a creature of the 20th century and really the second half of the 20th century, and very much mirrors the history of the ACLU. The ACLU is by no means solely responsible, but the ACLU played a part in that change in our understanding of the Constitution, because we began to go to court to try to enforce its provisions. And what started out very much as a free speech organization, I think, has really transformed over the years, and now very much sees its mission as protecting, all rights for all people, as defined in the United States Constitution, the civil rights laws that have been passed to enforce it, both at the federal and the state level. And so the organization at this point is really quite large. We have, if you add both national lawyers on the national staff of the ACLU and lawyers who work for ACLU affiliates, probably about 200 full-time lawyers. And then we have literally thousands of other lawyers who, throughout our history, have worked with the ACLU on a pro bono basis, volunteering their time to work with us as cooperating attorneys. So it's a large public interest civil liberties law firm. A lot of people ask that question, and there's been a lot of time and energy spent defending it. When I was first chosen to be legal director of the ACLU back in 1993, I remember the first interview I had asked me that question, whether my appointment said something about the emphasis of the organization on civil liberties and civil rights. And what I said then, I still believe, which is, I think in many ways it's a false dichotomy. I think of civil rights as part of civil liberties. It's certainly part of the ACLU's mission, and that the defense of civil liberties, even if you interpret it, pure in very narrow terms, is a powerful engine that drives the civil rights movement. If you look at the cases decided by the United States Supreme Court in the late 50s and early 60s after Brown versus Board of Education, most of what we think of as the Supreme Court's civil rights decisions were actually First Amendment decisions protecting the right of civil rights protesters to take to the streets and build a political movement. So I think the two work glove in hand, but we have a very, very vigorous, and have had for many years, very, very vigorous, I will say, traditional civil rights program as part of our mission. The other thing that I think is just important to say is that while we do a lot of litigation at the ACLU and we have a heavy Supreme Court practice at the ACLU, we are not merely a litigation organization. We are an advocacy organization. And if anything, over the years, we have spent more resources building up other parts of the organization, both the lobbying effort that we do in Washington and we do in state capitals around the country, grassroots advocacy, and a communications program. Because I think one of the lessons those of us who do this work have learned from some of our greatest victories, from Brown versus Board of Education, from Roe v. Wade, is when you're trying to achieve cultural and institutional change. Litigation can be an important engine to achieve that change, but it rarely is sufficient in and of itself. That civil liberties and civil rights are ultimately political movements that require political change, and to do that, you have to take advantage of, you have to bring the society along with you. And you therefore have to take advantage of all the advocacy tools you have at your disposal, and we very much try to do that. And I think we see that playing out today in gay rights and the incredible momentum, almost unimaginable momentum that is building towards what I'm sure is going to be the very swift recognition across the country of a right to same-sex marriage. I don't think the courts are leading that movement. I think the courts are reflecting a broader cultural change. I think it's clearly part of a broader social movement, and I think there's a pull and tug. I think the courts have led in some places, and the courts are running to catch up in other places. And it's never in a very conscious way. I don't believe judges read polls. I don't think that's the way they make decisions. But judges are creatures of their society, and just as we all are. And when social attitudes change, I think that is inevitably reflected not only in the work of legislatures, but in the way judges think about these issues. And I think for many judges, for many people in this country, the idea of same-sex marriage a generation ago was unimaginable, just because it was so far beyond their life experience. That's no longer true, and what was once unimaginable, I think, has now become inevitable. Yes, but a decade ago, of course, was 50. And also, since the Windsor decision, which we were really privileged to be co-counsel on, since the Windsor decision, we have, as of last night, 12 decisions, all of which have recognized marriage post-Windsor, with not a single decision going the other way. But I don't think it's simply a question in this instance of counting up the number of states and saying how many are on one side of the line and how many are on the other side of the line. I think you have to look at the way gay men and lesbians and transsexuals even are treated now in popular culture, how they are treated on television, in the theater, in movies, their appearances on a routine basis in the marriage pages of our major newspapers, the number of people who have simply come out of the closet in the last 2 decades. And so it's much harder to talk about we versus they when you realize that the person you were thinking of as a they may be your own child or your own nephew or your neighbor or your co-worker. I think all those things are much more powerful indicators of where the culture is going than simply counting up the state laws. Quick depends on when you start counting, right? Because we went through centuries, if not millennia, where gay people had no rights whatsoever, and were not recognized and were treated as blasphemers, and were forced into a closet and denied the opportunity to live, be who they wanted to be and who they were. And so it took a long year, many centuries before we saw any movement at all. But once things started to move in the last 15 or so years, they have moved very, very quickly. And I don't think there are very many people, and I will say I would not have predicted if we were having this interview 15 years ago, 10 years ago, maybe even 5 years ago, that we would be in the position we are today, and that all of these obstacles and dominoes would be falling as quickly as they are falling. Now, I'm tempted to say that's happening because it's the right thing to do, but there are many things that I may think are the right thing to do that don't happen, and there has been a lot of discussion in my community about how to understand this phenomenon, and in some ways how to bottle it. What lessons can we learn from it, and how can we then apply it to other social movements, whether it's the traditional civil rights movement, whether it is the reproductive rights movement, which is going through a real struggle at the moment. And so it's a totally fair question, and I'm not sure there's a simple answer to it. Well, I don't balance them against each other in the sense that I don't think we say we ought to be doing more here and less there, if that's what you mean by balancing. But I do think that we think about the question of how you can understand what we are tapping into, given the current judicial response to gay rights issues, and can we tap into that same nerve when we come and deal with traditional civil rights issues. I think part of the struggle in litigating civil rights cases before the Supreme Court is traditional civil rights cases before the Supreme Court, is that there is a portion of the Supreme Court that essentially thinks that battle is over and that battle has been won. And the gay rights movement is at a very different stage. We are still fighting de jure discrimination in the gay rights movement, and in the civil rights movement, we're largely struggling now with de facto discrimination and overcoming a legacy and a history of centuries of de jure discrimination. But we don't have laws anymore that overtly treat people differently on the basis of race. So I think the Supreme Court sees the two issues as distinct, and part of the struggle that we have, I think, is an effort to persuade the court that there is an ongoing problem, and serious problem, and in some ways a problem that is getting worse, of racial discrimination in the United States, and that the court has to be part of the solution. One of the places that I think the court went off the rails several decades ago is when it ruled in a case called Washington versus Davis that the 14th Amendment only prohibited intentional discrimination. It didn't prohibit state actions that had the unintentional but the undeniable impact of treating one race worse than the other, and that has made these cases hard to litigate. I think so, and then that in turn makes it even more frustrating when the court strikes down important legislation that's been adopted by the political branches to try to remedy the ongoing vestiges of discrimination, as the court did last year with the preclearance requirements under the Voting Rights Act in Shelby County. I think that decision was wrong, and I think it's already had a serious impact. We have seen a small avalanche of state laws that I think never would have been pre-cleared by the Justice Department under the old Voting Rights Act, and now have to be litigated state by state by state in a way that is very costly, very time-consuming, and very difficult. Yeah, I think those cases now require very extensive factual records to try to persuade the court that the discrimination we are fighting is not simply a matter of history, but a matter of current reality. And we recently obtained a decision from a federal district court in Wisconsin striking down that state's voter ID law. That case is on its way to the Seventh Circuit. But the decision by the judge in that case was based on a voluminous factual record, extensive and quite expensive expert witness studies, and he attached a series of appendices to his written judicial opinion in which he went through all of the statistical evidence that demonstrated, I think irrefutably, that these voter ID laws did almost nothing to combat a problem of fraud, voter fraud, because that problem didn't exist, but they had a very dramatic impact on the ability of racial minorities to vote in the state of Wisconsin. So I think a lot of this now is a real slog to make the case. And when you make the case in court, you're simultaneously hoping that you make the case in the court of public opinion as well, because one of the things that litigation does is litigation is an opportunity to tell a story. And if you tell your story well, then hopefully it has a wider audience. Yeah, all of our advocacy activities now are very consciously and carefully integrated. And so the records that we compile in the course of litigation are then used in front of legislatures to either discourage them from doing bad things or encourage them to do good things. And the stories that we develop in the course of litigation, we try through our communications department to get out to a wider audience, either through social media or through our own website or through talking to journalists who we know are interested in these issues. And so we almost never approach things anymore purely as litigation matters. We think of, there's a goal we have in mind, and we think of how do we best achieve that using all of these parts of our toolbox. Well, I don't think that, when you get in court, the process doesn't look much. I mean, maybe we think more about facts now than perhaps we once did. When I first started the ACLU, a lot of our work, frankly, involved what we call paper cases. They were summary judgment motions. We were fighting about the constitutionality of a statute. There wasn't much dispute about facts. Now we're much more heavily engaged in facts than we once were. But when we get in the courtroom and we're presenting witnesses, we're writing briefs, we're arguing cases. We're lawyers, and we do what lawyers do. And I don't think that has that has significantly changed. But when we think about what our priorities are going to be as an institution, and we go through that process continuously, we think about what our priorities are as an institution. One of the things we think about, not the only thing we think about, but one of the things we think about is what are the areas where we think we can have the most impact and the greatest likelihood of success. And when we are trying to evaluate our impact and our likelihood of success, we don't think only in terms of court victories. We think of the various ways in which we might succeed and in the ways in which a success, in the legislative arena can reinforce a success in the courtroom and vice versa. Well, the way the organization handles it is that the lawyers are, by and large, specialists, subject matter specialists. And so the legal department of the National ACLU, the department that I direct, is divided into 14 projects that span the scope of work that the ACLU does, from women's rights and reproductive freedom to immigrants' rights to prisoners' rights to speech privacy and technology to voting rights to capital punishment. There are 14 different areas, and the lawyers in those areas focused almost exclusively on their subjects and are expected to become, and I think do become, national experts in those fields. They're deeply immersed in it on a day-to-day basis. I, because of my responsibilities as the director of the program, and by dint of just my interest and personality, I'm a generalist, and so it's probably fair to say that there are very few areas that I know with the depth that the specialists know, but I do have an understanding of the breadth of the issues that the ACLU covers, and to me that's always been interesting. And one of the things, one of the many things that is both fascinating and challenging about working in an organization like the ACLU is because we are not a single issue organization. There are moments when we have to confront cases in which there are two sides are both making a claim of rights, and we have to try to figure out some principled way to resolve that clash, and that's never simple for us. Sure. Well, the example we used to give in the old days, but it's largely an historic example, was free press, fair trial. So you have a suppressed confession that is leaked to the newspaper, and the newspaper wants to publish the confession, and the defense lawyer comes in and says, my client can't get a fair trial if the suppressed confession is published, and we care about the rights of the press, and we're opposed to prior restraints, and we care about due process and fair trial rights, and so how do you figure that out, right? But the law has more or less figured that problem out, I think. And so now the current example, and there's a case in the Supreme Court this term, is abortion clinic picketing. Because we are very deeply committed to reproductive choice and the right of women not only to have an abortion, but be able to access abortion, to be able to walk in and out of clinics without being harassed or threatened or intimidated. But we also believe, notwithstanding our support for reproductive rights, that people have a right to have a different view and to express that view on the public streets, including outside clinics. And how do you balance that when you have either a claim that the police are doing too little to protect the rights of the women going in and out of the clinic, or doing too much to infringe on the rights of the protesters? And there's a particular case from Massachusetts before the Supreme Court this term involving Massachusetts' solution to that problem, which was to create a 35-foot buffer zone outside of clinics in the state. And those are hard cases for us, and we really struggle with them. No, I don't think it's ad hoc, although it's a conversation that we wind up repeating a lot, and because you're trying in those cases, I think, to truly balance competing rights. no two cases are exactly the same, because in one case the restrictions on protests can be more onerous than in another case, and or vice versa, and that may lead you to a different balance, right, and a different bottom line. But there is certainly an extensive process of discussion that takes place, and it takes place within the national office, and it involves typically the people who work on reproductive rights and the people who work on free speech rights, and it involves not only the lawyers at the national office but the state affiliate, whose law has now been called into question because they may have lobbied for or against that law as it was going through the state legislature. And we all get together, and through a series of discussions, we try to figure it out. And then part of my job, certainly when we're taking positions in the U.S. Supreme Court, is to try to ensure that our positions are consistent and defensively consistent across cases, and that we're not saying something in this case that contradicts something that we said last year or that we may want to say next year. And that part of the exercise that we often go through at the ACLU, it's a little bit of an exercise, but I think it's a useful one, especially in free speech cases, is we say, let's assume the politics were reversed, and that the protesters were articulating a message that was 180 degrees from the message they are in fact articulating. What would our position be? Because we really are, in that sense, a nonpartisan organization that tries to operate on the basis of neutral principles, and whatever rule we come up with has to be valid not only for speech we may institutionally support, but for speech we might institutionally oppose. And that's, it's not simple. We may not always get it right, but it's a process I think we take very, very seriously. I think both the premise and the conclusion of that question are wrong, in fact, because we are in many ways deeply connected to the constituencies that we represent. We have a very deep connection to the reproductive rights community. We have a very deep connections to the gay and lesbian community. We have deep connections to the civil rights community. The fact that we have affiliates in every state gives us, almost uniquely among the major civil rights organizations in the country, a presence on the ground everywhere. The NAACP has that, for example, but many organizations do not. So it's not simply a question of lawyers or lobbyists sitting in New York or Washington and trying to dictate to the states. I mean, most of this for us bubbles from the ground up. So I think we are deeply, in fact, connected to the communities that we represent. And then, I like to think that we have, over the 94 years that we have been in this business, developed a reputation, certainly among judges, and I hope among the justices of the Supreme Court, as an organization that is principled, and B, is good. And so I think when people read our briefs, they may agree or disagree, but I don't think that most judges come to them thinking we have a particular axe to grind. I think they come to it saying we're involved in a sincere effort to interpret the Constitution according to a set of principles, for sure, that we believe in, but in a truly nonpartisan way. I mean, we have represented clients on the far left and been pilloried by the right for doing so, and we represented clients on the far right and been pilloried by the left for doing so, and I think that has served the ACLU well. Well, we don't choose to do one versus the other. We do both, and the amicus practice, we file amicus briefs in lower courts on occasion, and certainly our state affiliates may have an amicus practice in their state Supreme Courts, for example. But the National Office of the ACLU, the bulk of our amicus practice is focused on the Supreme Court, In any given year, the number of direct cases we have obviously goes up or down. Last term, the 2012 Supreme Court term, we had 6 cases in which we were direct counsel or co-counsel. I mean, that was for us, even for us, a very busy year. And they were big cases and important cases. This term, the 2013 term, we have 3 cases in the Supreme Court. We will, in addition to whatever the direct docket is, generally file probably a dozen or so amicus briefs in any given year. So over the past decade, I would say we've averaged between 15 and 20 filings a year in the Supreme Court. And if the Supreme Court is hearing 80 cases a year, it means we're filing in something between 20 and 25% of the Supreme Court's cases. And when we make a decision about whether or not to file an amicus brief in the Supreme Court, there really are 2 criteria that I use. One is this an issue that is important to us, right? Is an issue that we are concerned about for some reason or another? And there are a lot of issues that fall into that basket, just given the breadth of our work. And then the second question is, do we have something to offer? I really do not believe in filing repetitive briefs in the Supreme Court. We are too much of an institutional repeat player in the Supreme Court. I'd like to think that our briefs get read, and I know that they will stop reading them if we're not saying anything that's of value to them. So there may be cases where we think we care about the issue, but it's well covered and we have nothing to add, and then we won't file, or we'll join with somebody else, right, rather than file a second brief. And it's always hard to know. There's a lot of debate going on, obviously, about the impact of amicus briefs, and that practice has changed very much over the course of my tenure. When I first started doing this in the late 80s, there was not nearly the level of amicus involvement that there now is in the Supreme Court. You never saw 40 briefs. By and large, the law firms didn't have Supreme Court practices the way they now have. There wasn't a specialized Supreme Court bar the way there is now a specialized Supreme Court bar. So it hasn't taken us out of the business, but it makes it by a long shot. But it does make me think more carefully always about what is it that we have to add to the mix. And all I know, and I like to believe this because it supports the decisions and work that we're doing, is when periodically there are academic studies, usually of former clerks, surveys of former clerks about what briefs get read and what briefs have impact. The ACLU is usually up there on the list, and it's very important for me for the organization to maintain that role and to maintain that reputation. And we won't maintain that role unless we maintain the reputation, and that means filing good and useful briefs. All of the above. We write a fair chunk of briefs. Sometimes we file them simply in the name of the ACLU. Sometimes we go out and we'll try to solicit, for example, if it's a brief, in the Hobby Lobby, the contraceptive care brief, where there were an enormous number of briefs being filed. The brief that we wrote was a brief that talked in some ways about the civil rights history of religious refusals, right? To try to help the court to understand that this is not a new phenomenon, and that unfortunately religion has been used as a claim justification for discrimination in many other contexts and involving many other issues over the years. And in most other contexts, we've now rejected it as illegitimate. We don't allow somebody to say, I don't want to serve a black customer because the mingling of the sexes violates my religious beliefs. Why should it be any different here, right? And so we try to give an historical context to the current dispute. And when we did that, we thought that brief would be enhanced if it had a broader constituency of civil rights groups that joined it, and civil rights sort of icons. And so we went out and tried to get those people to join our brief. Other times we write by ourselves, and then sometimes, as I say, we will join other people's briefs. Well, I think you always think about what makes for a successful brief. If what you mean by a successful brief is a brief that might move somebody to vote the way you want them to vote, and often, especially in amicus briefs, you may have the luxury of, because you don't have to address every issue in the case, you may have the ability to focus your opinion on a particular justice, or a series of justices who might be in play in any given case. I don't think being cited in Supreme Court opinions is, that's evidence that your brief was read, but I don't think the fact that you're not cited means that it didn't influence the decision-making process. Amicus briefs are rarely, not and occasionally, but rarely cited in Supreme Court decisions. I think there are two things, or three things, I think that an amicus brief can do. Sometimes, although this is increasingly uncommon, but sometimes there just is not a very good merits brief, and that in effect, if you care about the issue, you're writing something that is essentially a shadow merits brief because the actual merits brief has not done a good job of addressing the principal issues in the case. That used to happen more often than it does now, but it still occasionally happens. Or much more common is you have a situation in which you have a very, very competent merits brief, but everybody's dealing with a 15,000 word limit on your merits brief, and there may be issues that have been identified that the principal merits brief just doesn't have enough space to address, in which case an amicus brief can fill that hole by devoting more space to something that the merits brief has less space to discuss. And then the third thing, actually maybe there are four things. The third thing that you can do is just empirical. You can present the court with empirical evidence and academic studies and various other things that can help to educate the court as it thinks about the issues. And then the final thing, and this doesn't tend to be something that the ACLU does, but I think it matters to the Supreme Court, is you can submit an amicus brief that is very powerful because of the names on the cover, almost without regard to what is between the covers. And so when the Supreme Court decided the first Michigan affirmative action cases, Gratz and Grutter, in 2003, it was clear that briefs that were submitted on behalf of Fortune 500 companies, military leaders, had a tremendous impact on the court. And I think that impact would have been almost as great if the court never opened it up and just looked at the names on the covers. Well, if you just talk about last term again, the 2012 term, where we were lucky enough to be co-counsel for Edie Windsor. That case was a thrill. Everybody in the court felt like it was an historic moment. The case was argued by Robbie Kaplan, who's a partner at Paul Weiss. There was a sense, during the argument, that this was going pretty well, which buoyed people. We had the perfect client in Edie Windsor, and so all of that was a thrill. There are other times when you feel like you're really obviously swimming upstream, and that it's very hard to somehow penetrate. And for me, the biggest frustration over the last several decades has been the erection of a whole series of procedural obstacles that often make it very difficult for us even to reach the merits of the case. You bring a case because you want to reach the merits, you want a decision on the merits. And we very often find ourselves fighting on a different terrain, fighting on the question of whether or not the clients have standing. Increasingly now, whether the pleadings were sufficiently specific. or most commonly of all, whether the defendants, even if they violated your client's rights, are entitled to qualified immunity because the law was not clearly established. And so for me, I hate to lose. I want to win every case that we bring. I think we should win every case that we bring. But I feel the greatest sense of frustration when you just can't get past that first stage. I don't think it's a consequence of the professionalism of the bench. That's not my view on it. And I think we obviously, I agree with the Chief Justice that you want a group of highly intelligent, engaged, learned people on the bench. I disagree if what he is suggesting is that you can only obtain that result by going back to the same well over and over and over again. I think there is benefit from having a diverse set of life experiences on the court, and I define that very broadly. I think the fact that there are very few people on that court who have ever been trial judges or trial lawyers hurts the court as it tries to sort of understand how the judicial system operates. I think the fact that we now have 3 women on the court is terrific and makes it a very, very different court than it was when there was only Justice O'Connor, and I remember the days when there wasn't even Justice O'Connor. So I think that diverse experiences on the bench produce a better bench, and that we can and should strive for that without any sense that we're sacrificing quality in the process, because I don't believe that. I don't want to attribute motives to the court. There's an explanation for each one of those procedural barriers, and in isolation, I understand where they come from. But cumulatively, they've made it a lot harder for a lot of clients to get through the courthouse door, and have left a lot of claims that I think deserve to be adjudicated on the merits unadjudicated on the merits, and that seems to me unfortunate. Well, I think that I came to work at the ACLU, and Warren Burger was Chief Justice. So, but there were people here at the time who had been through the Warren Court. I never had the luxury of being a civil liberties and civil rights lawyer before the Warren Court. And so most of my career has been spent with courts that we would think of as relatively conservative. And I guess I'll say a couple of things. One is, for a long time, there really was this fear that kind of major landmarks of civil liberties and constitutional law were in jeopardy, and would fall. Whether that was Miranda, whether that was the exclusionary rule, whether that was Lemon v. Kurtzman, which is the Supreme Court's still default rule in Establishment Clause cases, Roe v. Wade, obviously, right? And interestingly, all of those precedents still sit. None of them have been formally reversed. The court has chipped away at the margins in various ways. But I would say the more significant thing that the court has done, as I said, was not to frontally attack those precedents, but to simply make it harder to assert rights under them by creating other barriers that limit your ability to press your case. The thing about the political affiliation of the court. The court was pretty political in the 30s. But I do think that there is a danger if the court is perceived to be another political institution in terms of its position in the American democratic process, right? Because the ultimate question of constitutional legitimacy always is who allows these 9 people to overrule the popular will as adopted by the legislature, and the answer is we don't live in a pure democracy in this country. We live in a constitutional democracy, and these judges have a different role and they perform a different function and they do it differently than politicians, right? And if people stop thinking that they're not doing it differently from politicians, the court will suffer. I actually do think they do it differently than politicians. I don't think they approach their jobs the way a senator or congressperson approaches his or her job. But I think that what has happened over the years is that the nomination process and the vetting process have become so sophisticated and so comprehensive that by and large, presidents who appoint judges and Supreme Court justices have a pretty good idea of what it is that they're going to get at the end of that process. And I think the reporting on the Supreme Court has changed. You know, whether the reality of the Supreme Court has changed or the reporting has changed or both, I think is an interesting question. But again, when I first started doing this, you would rarely, I certainly can't remember, reporting on judicial decisions that would announce the political affiliation of the judges who, in the majority and the dissent. And now that's a routine part of reporting on the judicial branch at the Supreme Court and at lower courts as well, right? If not the political affiliation of the judge, the political affiliation of the governor or the president who nominated and appointed them. And you know, on the one hand, I think that's an interesting, it's an interesting data point, and it often is predictive of outcome. Not always, but often can be predictive of outcome. On the other hand, I think it's something lost when we start thinking about the Supreme Court in those terms. You know, I think it is better, and this is the way I try to talk about the court, just to talk about the merits of their decisions on the merits. One of the things that remains very impressive about all courts, but the Supreme Court especially, right, as opposed to the political branches of government, is that at the end of the day, they have to provide a written defense of their decision. And that defense is either going to be persuasive to people or unpersuasive to people. Right? And to me, we're better off focusing on the substance of that dispute than on, you know, whether the person who wrote it is a Republican or a Democrat. And yes, in broad brush terms, you can look at the Supreme Court and say there are certain justices that are more conservative and certain justices that are more liberal and certain justices that are originalists and certain justices that believe in a living constitution. And as generalities, you know, that is helpful to a certain extent, but only to a certain extent. It's a much more complicated institution. I think they are much more complicated people. The process they go through is much more nuanced than that, and like all generalities, it breaks down, you know, at various points, and you do wind up with unexpected alliances on unexpected issues, and so I think that the debate that we ought to be engaged in is not the question of where the 5 justices in the majority in Shelby County, Republican or Democrat, and what does that tell us, but you know, who had the better argument here about whether or not this effort by Congress that had been reenacted, 4 or 5 times since 1965 to address ongoing voting discrimination, where the Congress had acted within its congressionally delegated powers. And people can dispute that. People obviously did dispute that. I think that dissent was more powerful, and it was right. And that's where I think we ought to be, we ought not to be talking about labels. We ought to be talking about substance. Well, the court also often writes fractured opinions, and more frequently now than it used to. And John Roberts came in and said, I want more unanimous opinions. Haven't quite gotten that. He also said, I want more cases, and hasn't quite achieved that either. Courts used to be dissents used to be much less common than they are today. And one of the things about other legal systems, I digress here for a moment, but it is interesting. There are other legal systems whose highest courts do not permit dissents. They're like juries. And then the notion is, the cultural idea is, the law can only mean one thing, and your job is to tell us what it means. And you have to just keep banging heads until you figure it out. We have a different system, and I think we gain, because you don't get compromise verdicts in quite the same way, right? And then the dissents sometimes become majorities later in time. But when you have fractured decisions like the school prayer case, there's a certain amount of nose counting to try to figure out, well, what exactly it means, and what's the least common denominator, and what's the holding of the case, and what's the dictum in the case. But that's not, to me, the most interesting thing about the school prayer case, Town of Greece case, which I found very disappointing. We had filed a brief in that case. We were on the other side. But what I find disappointing in the case is I really believe that the majority underestimated the impact on a religious minority when you're sitting in a room and you're asked to observe, at the very least, a prayer that belongs to the majority religion, which you don't share, and your choices are either to remain silent when everybody else is praying, or get up and walk out in the face of your neighbors. I think that's a very sort of powerful a message of exclusion that is sent to minority members of the community, in this case minority faiths, that the Constitution was designed to protect us against that sort of religious division. And I read the majority opinion, and I thought to myself, somehow or another, that didn't get through to the court. And so as a litigant, I think to myself, well, what do we have to do the next time to try to make the court understand what this experience is like from the perspective of an outsider, somebody who it might already be, for other reasons, marginalized within the community. Because one of the reasons that we have a Bill of Rights, of course, is to place limits on the power of the majority, to exclude the minority, and to do that, not to use President Obama's term, but I will, it requires some ability to put yourself in the position of that excluded minority. And I think that the burden on those of us who litigate in the court is to get that message through, is to get that message through. And so if you're thinking about amicus briefs, for example, to the Supreme Court, it's not clear the Supreme Court needs another amicus brief on Establishment Clause doctrine. But maybe an amicus brief somehow trying to tell that story, in a way that resonates at a human level with the members of the court, can be a powerful thing to do. Well, we take as part of our mission the responsibility of trying to help people understand the Constitution and our constitutional tradition and what it means and why it's important. We're one messenger. We can reach only so many people. We're constantly trying to figure out ways to expand our audience. But I'm with Sandra Day O'Connor here. I think one of the real problems we have in the United States now is a lack of civic education and a lack of understanding, even among very highly educated people, of what this document means, what the Constitution means, why we have it, how it applies, what rights it protects, and why it protects them. And I think that it's much easier to lose your rights when you don't even understand them, and we all need to do a better job in helping people to understand what their rights are. Well, let me just say before answering that I think I'm a real optimist, and I think you can't do this job and work for organizations like the ACLU, and not for as long as I have worked for the ACLU, unless you basically have an optimistic view of the world. And progress is certainly never linear. It proceeds by 2 steps forward, 1 step back. But if you look at where the world was, certainly when the ACLU began now nearly a century ago, and you look at where the world is today, there has been tremendous progress towards more freedom, more equality, more liberty for more people. And the benefit of working for an organization that has a long history like that is it enables you to sometimes step back and take the long view and say that we really are, I think, accomplishing our mission in ways that we couldn't have imagined, 50 years ago. Just like 20 years ago, we couldn't have imagined gay marriage, and so it's always discouraging when you lose a case. It's always wonderful when you win a case, but I feel pretty good about not only the ACLU's mission, but its progress toward achieving that mission. That said, there are when I think about the future. I think a couple of things. The world is now grappling, and the court is grappling, and the ACLU is grappling with how to understand what our rights are and how to preserve those rights in a digital world. And I think that issue is not going to go, we're not even sure what questions to ask, let alone what the answers to those questions are. And part of the consequences, one of the consequences of the Snowden revelations is they have at least forced all of us to think about issues that many of us, I think, were oblivious to, or certainly didn't understand the technology involved. And the court is just really wading its toe into those issues. When you look at the GPS tracking case from a couple of terms ago, United States versus Jones, where Justice Scalia writes a plurality opinion where he still wants to talk in terms of trespass, and then you have others who say, well, it is a trespass, you're right about that, but it's also something else, and we have to figure out what that something else is. I think that issue will be with us for the foreseeable future. I wish this were not so, but I think the balance between liberty and security in a national security state is something we're still struggling our way through. And I think we're not going to be able to resolve that question until at least we have some transparency and accountability for what has gone on in the past. And then I think race, sadly, will always be less in this country. We're going to have to continue to deal with it and grapple with it and address the questions that flow from it in a society that is becoming more, not less, diverse, and sadly more, not less, segregated over time. And so I think that issue doesn't go away. Well, it was a conversation that wasn't taking place at all, and now it's a conversation that is very much taking place. And I think it wouldn't have taken place but for Snowden. I think that's just a fact, and I think that a climate of fear is never a good climate for civil liberties, right? And you can have different kinds of fears. You can have the fear of another terrorist attack, right, which leads to certain decisions. and a certain balance between liberty and security. Although it is interesting, so much of this always depends upon how you ask the question, and it is just as a general principle true when people say that they're willing to sacrifice a certain amount of liberty in order to obtain security. What they almost always mean is somebody else's liberty and not their own liberty. But that's one kind of fear that creates real civil liberties challenges. Economic fear creates another set of civil liberties challenges. It can often, I think part of what we're seeing in the immigration debate and the immigration backlash is a sense of just the dislocation of the current economy and where the jobs are coming from and who's taking them and all those kinds of things. So those things create challenges, but these are never battles. Let's just get back to my previous point. There's not going to be a single court case, whatever that court case is, that's going to make us say, all of a sudden now I figured out what the right balance between liberty and security is, or now I understand privacy in the digital world, or now I understand what immigration policy in the U.S. ought to be and what fair treatment for new immigrants is. These are parts of an ongoing conversation. And so litigating in this world is different than if you are a commercial litigator and you're involved in a dispute about the terms of a contract, and when the case is over, somebody has won and somebody has lost, but the dispute is resolved. These are much larger social, cultural, political, legal issues that don't end with a single court victory and don't end with a single court loss. And you have to be able to think in those terms, I think, in this world. Well, the founder of the ACLU, who was a man named Roger Baldwin, used to say there are no new civil liberties issues. They're just the same issues over and over and over again. But it's like the Supreme Court says on qualified immunity cases, it depends upon what level of generality you're speaking. And so at a very high level of generality, that's true. When you get a little more granular, that's less true. And even if we ask the same question, we're asking the same question with a very different set of evolving and maturing cultural and social understandings. I mean, you can ask yourself the meaning of life when you're 15, you can ask yourself the meaning of life when you're 30, and the meaning of life when you're 70, right? It's the same question, but you're going to approach that question in a very different way. I think each one presents its own unique challenge. I think that the digital revolution, though, creates a sort of a world that we really don't fully comprehend. I think with some of the issues that have been with us for a longer period of time, we understand the world and we're just trying to figure out what to make of it and how to address it. I think in this digital revolution, we're trying to really understand what the world is. Well, I'm certainly not going to rank the justices. I think certain things are just obvious, right? I think you want somebody who is, understands the law. I think this is a hard job. You want somebody who is capable of doing it, intellectually capable of doing it. But I also think it is very important to have justices who understand the experiences of the litigants who come before them. And it's harder if you're on the Supreme Court because you're not a trial judge. You don't have somebody on the witness stand who you can relate to because they're in front of you. You're reading a cold record. It's often a story that is very divorced from your own life experience. And I think the ability to sort of understand what it looks like from the position of the people on the other side is really very important, and I think you have to have a strong sense. I think it's important to be a good communicator. because the court is not only speaking to the lawyers and to the parties, it's speaking to the greater public, and its ability to sort of make its message understood to the greater public is an important part of what it has to do. And then I think you want a justice who understands, and this is a really hard question, the role of the court in this system of divided government that we have in the United States, and where it is appropriate for the court to intervene in order to protect individual rights against majoritarian excess, and when it's appropriate to let the political branches do their job. That's every justice draws that line, but I think every justice has to think about that question. I don't think anybody alive likes the current nomination process, and I would venture to say that includes all 9 people now sitting on the Supreme Court. I mean, there has to be, until the mid-20th century, the justices were not even interviewed as the nominees were not even interviewed as part of the process. There's got to be something between that and the circus that we now go through. So I don't know how to fix it, but I don't think it's in a good place.